This is Matt Bouchard with REIT.com, and I'm here for REITWise 2013, NAREIT's Law, Accounting, and Finance Conference. Joining me is Pardis Zomorodi, partner with Latham Watkins. Pardis, thank you for joining us.
Thank you for having me.
So the first question, it's Friday afternoon. You get a call from one of your REIT clients indicating that they may have violated one of the REIT requirements. What do you do?
Well, I think the first thing I do is tell them, don't panic, and let's figure out if you've in fact even violated a requirement. I've gotten those phone calls on a Friday afternoon even, where you have a tax director that, for example, is worried that a service that a new property manager is providing at one of their properties is a bad service and contain all of their rents. And when we dig into it and really look at it, it ended up that everybody got comfortable that the service was just fine. So, the first thing is figure out if you even have a problem. After that, even if you do have a problem, with so many cure provisions available statutorily and other ways that people know of that you can fix or cure violations, it's chances are that you're not going to lose your REIT status. For example, with respect to the asset test, there are 3 different cure provisions. And the first one and the easiest one to meet is the 30-day cure provision, which basically says that if you violate one of the REIT asset tests, you can cure that violation within 30 days after the end of the calendar quarter in which the violation occurred. The second one is for de minimis violations of the 5% or 10% asset test. And essentially, the REIT has 6 months from the day that it discovered the violation to either dispose of the offending asset or otherwise satisfy the REIT asset test. And the third one is for violations of more than de minimis violations of the 5% and 10% asset test, or violations of other asset tests. And with that, the REIT can avail itself of the cure provision if it has acted with reasonable cause and not with willful neglect, if it disposes of the offending asset or otherwise satisfies the asset test within 6 months of when it discovered the violation. It discloses certain information to the service and it pays a penalty tax. With respect to the other REIT requirements or other REIT tax requirements, there's also cure provisions there, but they generally turn on whether there's reasonable cause and the REIT not having acted with willful neglect.
And speaking of reasonable cause, what are some ways that a REIT can establish reasonable cause?
Very generally speaking, in order to have reasonable cause, the REIT needs to have acted with ordinary business care and prudence. Now, what does that mean? It means that the REIT has to have made a good faith effort to learn about the REIT requirements and to satisfy them and to try to comply with them. It means having a system of checks and balances in place that allows the REIT to not only identify foot faults and prevent them, but also when they identify them, to cure them in a timely manner. Another way that a REIT can have reasonable cause is to get a written opinion of counsel on an issue. The technical rule is that reasonable reliance on a reasoned written opinion of counsel can give a REIT reasonable cause. The opinion has to be reasoned. It can't just draw a conclusion and not provide any reasoning for it. It has to be written, has to be provided by a tax advisor, and also it has to be based on full disclosure of the facts. Now, what does that mean? It means that if the REIT has that opinion and the IRS ultimately disagrees with the conclusions reached in that, the REIT can rely on the reasonable cause cure provisions. The one important thing to note is that this rule that I just said is really in the regulations dealing with income test issues, but based on legislative history and other authority, people generally think it's good for any of the REIT relief provisions that rely on reasonable cause.
In today's current environment, what would you say is the most common concern expressed by your REIT clients?
Well, I think the most common concern for them is diligence readiness, which sort of goes hand in hand with exercising ordinary business care. It also comes up a lot because, in the past, the time between when a REIT decided that it was going to do a stock offering and the time that the stock offering actually launched tended to be longer. So they had more time to get the ducks in a row and to get the opinions of counsel that are generally required for REIT offerings. These days, they don't have that luxury. I mean, they decide that they want to launch an offering on Monday and the launch is on Wednesday, and if they're not diligence ready, nobody wants to hold up a deal because you're trying to get an opinion. So I think the practical implication of that is that REITs tend to have counsel more involved in day-to-day operations, and so I think that's probably one of the bigger things that we see.
Pardis, thank you so much for joining us.
Thank you.
For more on this and other REIT news and analysis, be sure to visit REIT.com.